Good afternoon. I'm Dejan Popović, Professor Emeritus at the University of Belgrade Faculty of Law and President of Serbian Fiscal Society, the national branch of FIFA. On behalf of Serbian Fiscal Society, I wish you to enjoy your stay in my birthplace, Belgrade, and in the event you are already attending. I take this opportunity to greet my co-chair of this panel, Professor Joachim Englisch from the University of Münster, who is with us online. I hope that everything is functioning well. We have 4 topics to be presented and discussed during this session. Each of the rapporteurs will have 15 minutes to present his or her paper. And then, after each presentation, we shall invite our panelists to comment on the issues raised by the rapporteurs. We changed slightly the way how we will present our rapporteurs. So we will start with Dick Molenaar, coming from Rotterdam, where he is a partner with All Arts Tax Advisors. He also has strong academic links with the Erasmus University in Rotterdam. Dick Molenaar's topic is how should we tax income on online influencers? The floor is yours.
Thanks, Professor, for the for the introduction and for the invitation to come into Belgrade. I had the chance to see the city yesterday because I was here already then, and yeah, I find it very interesting. So I'm happy to be here, and it's an interesting conference, and it was very nice to write the chapter for the book about the subject where you asked me for taxing the income of influencers. First, the introduction to the subject, although I presume that all of you know what influencers are, of course. Well, to start with, let's say, I would say it started with mainly with YouTube initially, also with Twitter first, Facebook, but it really got bigger with Instagram. And the idea behind it, especially with YouTube and Twitter and such, is that those social media platforms gave us, let's say, normal people a way to express freely what we are experiencing, what we are doing, what we like, what we don't like. Well, very often it's quite positive what you put on a social media platform, like what I did yesterday on Facebook with that. I was walking through the city here. I saw a group of musicians playing. I made a photo. I put it on Instagram and Facebook. I got 100 reactions because I was showing that I was happy that I experienced it. So it's very often positive. And it also gives us the availability, the possibility to listen to what others are experiencing. So the 100 reactions, though those people were happy that they saw me experiencing it. But not so strange. After some time, it seemed that some voices were louder than others. Some people have more to say, have more experiences, or make more out of it. And that they were already started with YouTube, and I would say that especially with Instagram, it really accelerated. It also gave the opportunity to connect with commercial activities. So it also, when on social media platforms, same as in newspapers and on television and radio, people are active. It also gives the opportunity to connect with services and goods which can be presented, can be supported, and of course in a different way from a normal classic advertisement, and very often a sort of very informal and not clear that it's really advertisement, and like that those products or services are really supported. On the other hand, the influencers have become sort of the new stars of this time. I'm not going to say that sports and regular entertainment, like I spoke yesterday evening with someone who went to see Ed Sheeran the other day in Switzerland, and I'm not going to say that those are not the stars anymore, but there is a new type of stars has arisen, and those are the influencers which are very much followed on social media platforms. And I named a few. I mean, very often it's sports persons like Ronaldo, or it's entertainers who are very popular also as influencers, but there are also those who don't do any sport at all. And what is also very interesting is that there are and that's in, I didn't add it, I already wrote it before, but it's in addition to the presentation before lunch about robots. There are also virtual influencers. They look like real people. We have one in Rotterdam where I come from, Esther Olofsson. She really looks very normal. It's also saying that she's coming from Sweden. She likes Rotterdam. She goes everywhere, but it is not a real person. It's a virtual person, and it's an influencer because she also presents products and services and such. Well, there has been I don't know by head where I have it from, but the size of the market of this influence and commercial is around 13 billion euros a year this year, is what they estimate. So it's getting very interesting. But of course, we are here for the tax aspects, and therefore I've listed the articles from what I would say the OECD model or the UN model or any bilateral treaty that could be linked to this type of activity and to the income coming from it. Of course, Article 17 might be Article 12 or Article 15 when it's employment income, but the very special Article 17 as an exception to all those other rules, I would say it's best to check this first, because if the income of the influencers would fall under Article 17, the other articles would be set aside. So I prefer to discuss the exception first, because otherwise, we're going to talk about the other articles, and that wouldn't make sense. The commentary on Article 17 does not give a definition for an entertainment or a sports person, but gives some examples. And I would say that that an influencer starting or using his or her personal life and experiences and such, what he or she is doing is very much entertainment, is very much showing to others, either scripted, either really written out before and directed, or perhaps very spontaneous, might also be, but that's not different from other types of entertainment, from film actors or from stage actors or musicians or such. That might also be very much scripted and can also be very spontaneous, like in jazz music. The commentary also speaks about mixed activities. So it also speaks about making advertisement, but is saying then it should be really clear advertisement. And the entertainment character should be very small. And I would say with influencers, they still bring it as their normal life, and the advertisement comes a sort of with it. It's not like normal advertisement. And there are also examples and a description about sports persons in the commentary, but I don't think you can say that influencers can be seen as sports persons. So when a football player like Ronaldo is putting all sorts of posts on Instagram or Facebook, then he doesn't do it as he's not playing football at that moment, of course. Sometimes he does, but we are not playing football, but he's more an entertainer then, and that's under the commentary also possible. My conclusion from this is that influencers most of the time, or let's say in more than 90% of the cases, can be seen as entertainers, and therefore their income should fall under Article 17. Well, then about Article 17, well, you will know that you might know that it started already. It was already inserted in the draft model of 1963, In 1977, the second paragraph was added to avoid that payments to others would be out of the scope of Article 17. And there was quite a dramatic report in 1987 showing that the article is in the model because entertainers and sports persons cannot be trusted. They try to go around taxation, move in low tax jurisdictions, do not declare their foreign income in their residence tax returns and such. So it is an anti-avoidance measure. And what also came in 1987 is that so when countries take this over in their tax treaties and of course in the national legislation, it might be hard to calculate what the taxable income would be, because normally, as we heard already in the morning, tax is raised on the profit, not on the turnover, but on the profit. And but with entertainers and sports persons going around to various places, it might be hard to determine the profit, and therefore the OECD, not really recommended, but gave also the option in the commentary to not tax the net, not tax the profit, but tax the gross income, but then at a lower rate. What we already heard in the morning about the UN model and about developing countries. But there are quite some problems with Article 17. With this taxation in every country that you go for your golf tournaments or for your DJ shows or Coldplay touring around the world, there are quite some problems because the tax credit method is recommended by the OECD. Some countries have the tax credit method in any situation, but European countries very often have the exemption method, and there is more proof needed for the credit method. You need to have the information about the foreign income, and that needs to be accepted by the tax administration. So I also wrote down that it might be that you cannot get a tax certificate. You've been to another country, you perform there, taxes be taken off, but they do not give you a tax certificate, or it is in the wrong name, the name of the agent or the management, or it is in a language that you don't know, and the tax administration says first take an explanation from me. And but what very often is happening is that excessive taxation happens, and that is actually because of this sort of recommendation by the OECD to tax the gross income instead of the profit at a lower rate, but mainly countries do between 10 and 30% tax on the gross income. That's the practice. Then, of course, the taxable base in the residence country will be much lower because all expenses need to be deducted, like your agency fee or your management commission or your assistance, or like with Coldplay, the 20 trucks that you have with you to go around. All those expenses need to be deducted, and therefore the taxable base is much lower than it had been in the country where you have been performing. So it very easily happens that the foreign tax is higher than the national tax, and especially when there is a limited company in between, and only the limited company gets the credit, while the personal on the personal income and the personal tax of the entertainer or the sports person, the credit is not allowed. So excessive taxation easily happens, and especially for small earners. It's also the case when the income is low, that with personal allowances and such, there is no or just small income tax to be paid, and then they are easily overtaxed. There has been a discussion at the OECD to remove Article 17. There are a few authors who already wrote about it, and there was a public consultation, and there was a proposal. Together with Mario Tenore and Richard Van, we wrote an article about it. Should Article 70 get the red card? So there was a discussion within the OECD, but in 2014, the OECD has decided to keep Article 70 for entertainers and sports persons. And the OECD gave 3 reasons, which are still in place. One is the resident states have difficulties with obtaining information about the foreign income. Albert Reiter already spoke about it this morning in the European context, that it can also be the case. Second is still the old reason that top stars are moving to Monaco or to Dubai or to Andorra or to places where there is no income taxation or just low tax. And the third is that source taxation can be administered relatively easily. Well, you've already read it. I believe that those three reasons are wrong. First, payments for performances, for sports events are nowadays always going via the bank. So it's not a cash world anymore as it perhaps, well, as it was in the 80s or in the 60s. So that has really changed. Or what would also be possible, and what Dr. Harold Grams wrote about in the year 99, you could introduce an exemption procedure before the income could be exempted in the source state, so that the tax administrations at both sides know about the income. So I would say those difficulties can be overcome. Second, and that's a main thing, is that Article 17 in a tax treaty doesn't prevent influencers, YouTubers, pop musicians, Formula One drivers like Max Verstappen. It doesn't prevent them from going to Monaco or Andorra to go and live there, because a tax treaty provision is not relevant when you move to a tax haven, because the tax havens don't have tax treaties. So you don't have to put an Article 17 in a treaty to prevent them from going to Monaco. They go there because there is no income taxation, and they accept the source withholding tax, which will not be taken away. It would be much better not to have an article like Article 17, because then those top stars would stay in their own country because they would be prevented from those foreign source tax. So the second reason from the OECD is actually quite simple. They don't understand how it works, which is. And third, and that's what we heard in the morning several times, a source taxation is not easy because you have to declare your income in 2 or more countries. I'm working for DJs who have been performing in 30 countries in a year, so they have income from 30. It's not easy. It's more complicated. It's much simpler. It's a risk of double taxation, and especially, as Albert Reitler from the European Commission was saying, it's causing extra administrative expenses. Not officially, but in talks over the years, it had also been said, also in 2014, when the OECD decided to keep Article 17, I heard from people in Germany and France, we want to keep it because of the tax earnings. We cannot let the Rolling Stones go out of the country and they not have paid tax, you know. But this is sort of fable. This is not a realistic argument. There have been figures from the government, from the tax authorities in Belgium over the years 2014, 2018. They have an 18% withholding tax there. You can file applications to deduct your expenses. And the tax earnings from both entertainers and sportspersons are between 17 and 21 million euros a year. So it's not that much. I mean, if you would extrapolate that to the UK and the US, it can become, let's say, a billion euros in the US, but still, it's not that much. And on the other side, as I explained already in my question this morning, as a country, you can collect this tax, but you also have to give tax credits for your residents who have performed abroad. So like for the UK, they can collect that 20%, or perhaps from April next year, their 90% tax from those sports persons playing the British Open golf, or the big stars going to Glastonbury to perform there. They can take that 20 or 90%, but they also have to allow to Coldplay living in the UK a credit for the tax that they have been paying abroad. So I I think that the balance is nil in the end, and it's not bringing anything, but only causing administrative expenses. Well, back to the influences as entertainers, as we experience them as entertainers. Quite an issue is, of course, I've made an example. Quite an issue is that it might be that they receive their income from another state than where they are performing, where they are acting, where they do their work. So like a Danish influencer sponsored by a UK fashion brand, by Nike, for instance, going to Spain, shopping there, going to Atletico Madrid and to show off with the football players who are also sponsored by Nike. I mean, that's a realistic influencer activity. But how is that done? Is Spain going to tax the income? Is Spain because there is no money stream from Spain to Denmark. There's a money stream from the UK to Denmark. That was also discussed this morning. How is that? Is that Article 21 then? But then under the UN model, you need to have a special clause in Article 21 to do it. And is Spain strong enough to apportion it partly to Spain, like the UK has done in the case of Andre Agassi, the tennis player, who had been playing at Wimbledon and won. Well, in the end, he reached the quarterfinal or such, and he filed a tax return and he wanted to reclaim a part of the withholding tax. And then the UK tax authority said, yeah, you're also sponsored by Nike and by Head for your tennis rackets. So we want a part of your sponsorship income being taxed in the UK. Such an apportionment. I mean, the UK managed to do that, and the High Court accepted it. And in the US, with Retief Goosen from South Africa and Sergio Garcia, the two golf players, the US also managed to do that. But other countries are not strong enough, are not developed enough to find this, and especially for influencers, this is complicated. Another issue is, of course, deduction of expenses. If Spain taxes it, can the influencer tax, what is it, her expenses? And how about the tax credit in Denmark? That brings me to perhaps a strange connection, but a connection to Pillar 1 and perhaps even Pillar 2 and Article 12b of the UN model, because this Article 17 for entertainers and sportspersons is not based on a permanent establishment. It is a matter of activity there. Coldplay is not having permanent establishment in all those countries where they are performing, and still they are taxed there. That's, let's say, the same principle as Pillar 1 has, and also as Article 12b has. Interesting for Pillar 1 is that already has been recognized quite early that you should set quite a threshold to take out the smaller and medium-sized companies for whom it would be too much administrative work to organize everything. And otherwise also the tax administration would be overwhelmed with, tax administrations in two countries would be overwhelmed with it. And interesting is that the tax administrations are cooperating there, which under Article 17 would also like to have, that we don't have to chase the tax certificates ourselves, but that the information is exchanged to other countries.
Your time is expiring, please.
Yeah. So that could be examples for Article 17. So my conclusions: influencers are entertainers most of the time, perhaps not everyone, and they fall under Article 17, which means taxation in the work states and no permanent establishment required. But it's interesting how to apportion the income then to the work state. I would say it doesn't work for virtual influencers, which is a connection to the discussion about robots, but that the company who created the virtual influencers, who is exploiting the virtual influencers, just pay tax on it. Article 70 perhaps can better be removed, but we're going to have a discussion in the next session, not after this. And interesting is, of course, the comparison with Pillar 1 and 2 and 12b. Thank you.
Yes, it was an excellent observation by Dick Molenaar on the fact that in the new environment, once the Pillar 1 and Pillar 2 are implemented, just a smaller fraction of income would remain to be taxed in the state of source, given new formula for allocation of taxing rights under Pillar 1. But let us now hear the observations of our panelists. To remind you, our panelists are Dr. Marcel Jung, partner with MLL Legal Switzerland, and Ignacio Gordillo, Ceca, Magan, Abogados, Spain.
Thank you. Many thanks for the presentation. I have just a small comment. I believe that the problems or the difficulty in application of Article 17 comes from the court decision in the UK and the US, where there was a very extensive interpretation of the rules. And if I look from my country, Switzerland has entered an observation in the commentary to Article 17, according to which advertising and sponsoring income is not in scope of Article 17. And Switzerland does also not apply such income because it's not directly derived in connection with the physical performance. And this is also upheld by the Swiss Supreme Court. So my proposal would be, instead of the abolishment of Article 17, to reduce the scope of Article 17 to the important issue. This is the income stream which is really directly generated by the physical performance of an artist or sports person in a source state. And I think it cannot be really compared with Pillar 1 and 2, because a sports person is physically present in the source state. This is the principle of Article 14. And the difference is a sports person is 1 day in a source state. There's no need for a 183 rules like a worker. And therefore, in my view, still, I think it's really reasonable to have Article 17 in the OSD model.
To have someone else in you?
Is there a question there? Yeah. Let's start with you. Okay. The microphone is no. We start with the gentleman in the first row, please.
Thank you, Dick, for the very interesting presentation. I agree actually that Article 17 should be kicked out from the model, from my perspective at least. But I do not really have a question, more a comment, a general comment, which I saw researching. You may know that I am a VAT specialist, but I also deal with individual taxation. And I always, perceive that there is an incumbent issue every time. And the issue is about characterization. So we stick to legal categories, and in our field, tax categories, or in my field, VAT categories, that basically no longer hold. So I wonder whether we should actually restructure our, system based on new categories. For instance, I did that with, I proposed that when I analyzed in a paper that was published this year, last academic year, in International Tax Studies about, the definition, the distinction between self-employment and employee. So what is the distinction with the Uberization of everything? So it's no longer, easy to define. We have the same issue with VAT categories. For instance, for place of supply, we define different supply based on what is their nature. The problem is, what is their nature when we have digitalization? So I really think that also you point out basically to the same, and even in a more prominent way with regard to entertainers, on the one hand, and artists. So what is an entertainer? What is an artist? I mean, it's difficult to define when it becomes so easy to become an artist, just, showing up with a video, on a YouTube. So I think I'm not sure whether we should perhaps redefine our categories, our way to think about tax in general and law in general. So it was more a comment, but I essentially agree that we should redefine Article 17.
Yeah, the gentleman in the fourth row.
Thank you.
You're
Thank
in
you.
the second, but okay.
Okay.
Okay, he was really insistent at the beginning, so please give
Andres,
him in the fourth,
okay.
and then you will get your.
Okay. Thank you. No, I'm first of all, thanks for the brilliant presentation. I have a couple of points. I don't think the problem is Article 17 itself. I'm in favor of maintaining Article 17. I agree with what Marcel said. But I think the problem is the lack of clarity of the commentary. And I think the example of the influencer is really illustrative in this respect, because the commentary mentions some persons that would meet, let's say, the criteria to be considered entertaining, but I think it makes confusion. For example, there is a reference in the commentary, which I've never properly understood, to a film actor who is performing in a television commercial, which I think is to some extent a contradictory concept, because an actor who is performing in a film is supposed to entertain. An actor who is performing in a television commercial, I'm not sure is there primarily to entertain. And I think the issue for influencers is really whether they are entertaining or they are there because they are to convince me to buy a shirt or the last pair of shoes, so to say. And then
like your first example is, for instance, George Clooney with Nespresso. Television commercial, George Clooney with Nespresso. It's very clear he is an actor, he's also acting, he's doing the same way. It might also be that it's natural, that it's his natural way of doing, but it's very clear that he's advertising. That's the main purpose, and an actor really advertising. But the difference with influencers is, when you watch it, you still have the feeling that they do their own show, that they're doing their own activity. And in the meantime, they're coming up with Nespresso cups, because they say, yeah, I'm at home, I'm having a good time, I take a coffee, and then there comes this Nespresso and it's put in. So it's not primarily advertisement, for them, but for those who are watching it, it's still the entertainment.
Yeah, and that's a good, but let's say then it becomes very subjective, what is entertaining and what is not. Last point, responding to Marcel, I think it's not really the problem with UK and US courts. I think the commentary has been, I must say, in this respect, clarified with the 2017 amendment. So the golden rule, or the rule of thumb, is whether the person, the sports person or the artist, would have received the remuneration from the sponsor without the performance. If the answer is yes, then the commentary says it's Article 17. Income is closely connected to the performance. I think that's a clear guidance and very helpful in practice as well.
Let us forward the microphone to the gentleman in the fifth row, please.
Thank you. Well, this is a question I had in my office in the university. It's an academic question originally, but I later saw that was also an issue in the practice. You know that 8 out of the 10 best paid YouTubers, Spanish YouTubers, are residents in Andorra. The tax authorities told them, well, be careful. We will be watching you. you might still be resident in Spain, but apart from that, in as much as all your viewers, which is not true because many viewers are in the US and Latin America, but most of your viewers are in Spain, we still can tax you on as non-residents. And my question here is very much in line with a question of Giorgio Beretta, also very much in line with a question of Mario, because I think that the way these people do money is totally exploiting our traditional categories of source taxation, because we shouldn't forget it. These people do money with advertising. That's the big money here. Google AdSense and private marketing affiliation. So YouTube is paying you per viewers or per views, and local sponsors are paying you per views or per links pressed. What is that? Is that a service or is that a royalty? Because if you see the contract with YouTube, there is a universal license of the content, not exclusive. It's said in the contract. It's not exclusive, but still a license. So are we talking about a royalty here? And of course, this might be crucial depending on the domestic sourcing rules and depending also on the treaties. And my question is whether you can give us some indication on this qualification.
Mr. Molenaar would answer.
Very short.
Yes.
I would say you don't need Article 17 for this, because they decided to move to Andorra. You know, let Spain and the other countries keep their source tax, their withholding tax, and because there is no treaty, there is no tax treaty, don't exempt the source or withholding tax. Just tax it. You know. Yeah, but I mean, if all the countries have their source withholding taxes and say we only exempt it when you show us a treaty article and you show your residence, and then we accept an exemption, then it's fine, because then they are taxed in Spain for what they get from it, even when they're living in Andorra.
Since we have 3 more rapporteurs and their discussants, I will allow just one more question, and it's to you, gentlemen.
No. Okay, is it better now? Sorry. I had always thought the reason for Article 17 was that these people could earn a very large amount of money in a very short period of time. That's what I always assumed was the basis of Article 17.
And
However,
why would that be a reason?
well,
Because there are also others who are earning a lot of money.
well,
in a
that's
short
where I'm
period of
going.
time.
That's why I've never understood Article 17. Why we as tax people should have to decide who is and is not an entertainer. That's a crazy question. That's not a tax question. I mean, a tax question would be: is somebody earning an exceptional amount of money in a short period of time? I would also add, on the other end, Article 17, by talking about entertainers, I mean, why is the source country concerned about the bassoon player in the Berlin Philharmonic, for example? I mean, it seems to me that the provision is wrong on both ends. It doesn't cover enough people if the concern is people making a lot of money in a short period of time, and it covers too many people if it covers the average person in an orchestra. It's just not a coherent provision.
I would say we have more opportunity to discuss it in the next session when Carolina Tetlock is going to talk further about it.
Thank you. It is now Professor English's turn to address us and subsequently to introduce the second speaker. Is there any online connection with Professor English?
He fell asleep.
If not, I will take the. Here he is.
Now he's the
We can't hear you, Professor English.
Professor English, can you hear us?
Okay.
Okay. Then you can introduce Martina Danz and her topic.
Otherwise, I do it if we can't hear. No problem.
Okay, she will do it herself.
Yeah. Okay. Thank you, Professor Popović, and thank you for the organizing committee for inviting me. I'm Martina Danz. I'm a PhD candidate at the University of Neuchatel, currently doing a visiting research stay at Columbia in New York. And I'm going to talk about taxation of crypto assets in light of the provision of the OECD Model Convention. So, first of all, just to give you an introduction, we are witnessing huge technology advancements in the field of decentralized finance in the last decades, right? Nevertheless, there is a huge lack of legislative response everywhere in the globe. Okay, authorities, they can't keep the pace with everything we're witnessing in technology developments. Why? Well, of course, some of the main elements there is non-physical presence, as we traditionally see that. So there is no physical presence in all market jurisdiction. And of course, the decentralized nature, which is the main feature of DeFi, of all those businesses. As consequences from a tax standpoint, as main challenges, among others, we are seeing income characterization. It's a huge issue, as of course, localization issues. Just to give you a little bit of the technology background here, I'm going to start with cryptocurrencies, which are the most known form of crypto assets. Crypto assets is a catch-all term that defines all kinds of digital financial instruments that are based on cryptography and that are decentralized by nature. Particularly cryptocurrencies, they are financial assets that are used as means of payment, maybe as a store of value too, so for investment purposes, but they don't grant any kind of rights to their holder. So this allows us to distinguish these kind of tokens from the others we're seeing, like utility tokens, which on the other side, they grant digital access to a specific service or application that is developed by the issuer of the tokens, or investment tokens, which are more like traditional tradable assets, maybe giving rights to some income streams like dividends or similar to dividends and interest payments. We've heard a lot about non-fungible tokens, NFT, in this last 1 year. They are a peculiar form of token, okay, so a bit different from the ones we already saw. They are known to be unique and not interchangeable. That's why we call them non-fungible. Okay, so one NFT doesn't equal one other NFT, like in the case of Bitcoins, other cryptocurrencies. What is peculiar with NFTs, I think their main feature is actually the representation on the blockchain of a identifiable physical or digital assets. That's the main feature. As the example in the picture, you may have an NBA shot, a video that is tokenized, meaning represented on the blockchain, uploaded and put into an NFT, or maybe a digital work of art, but also physical assets. And there's going to be more complicated, of course, because we don't know which kind of rules we apply. Do we apply the digital services rules, or do we actually refer to the physical asset underlying that NFT? Not sure. So we keep it simple. We just stick to digital assets that are tokenized here. So as I said, the integrated function is the main one of NFTs, and that allows us to guarantee the ownership and authenticity of those underlying assets represented on the blockchain, of course, and ideally the secure and rapid transmission of those underlying assets. So we've discussed a lot about tokens, any kind of tokens we can have on the market. All those kind of crypto assets, they rely on an infrastructure which is called blockchain, so distributed ledger technology. It works like a database, like decentralized database, where all transactions are recorded chronologically and that are shared and updated constantly with a huge network of users. So in order to make sure, since it's decentralized, to make sure that those transactions are legit, we have to validate them, right? There are many ways in which we can do that. The first one, and the most known one, and discussed also, is mining, so proof of work. In this kind of validating mechanisms, we have a supply of computing power in order to validate transactions. So we can see in the pictures servers working to validate transactions in a huge mining farms. But we can also witness solo miners, meaning people with their own computer and server at home doing these validating mechanisms on themselves. So in this case, when we validate transaction, we receive as a reward new coins that are issued, or maybe and transaction fees on the validated transaction. Mining shouldn't be confused with liquidity mining, even though the terms are quite similar. It's very different operation. In liquidity mining, we have a supply of crypto assets for investment purposes, so we just lend our tokens to other investors, and then we receive a fraction of the income they realize on those borrowed tokens. Second way, most known way of validating transactions on the blockchain, it's staking, also known as proof of stake, which is more interesting compared to mining because of environmental issues. So you may have heard a huge merge of the Ethereum blockchain that recently happened. Well, Ethereum is a huge blockchain, okay, that issued Ether, which is a cryptocurrency. And they just switched from a proof of work system to a proof of stake validating mechanisms in order to, maybe made some economies in terms of environmental energy consumption, because it was a huge deal and so much debated. So in this case, the difference is that we are pledging a certain number of tokens we're having on a specific protocol to validate transactions. So the higher the upright, the better the chances we're selected as validators, because we have a greater interest in keeping that particular blockchain safe and legit. So moving on to the tax analysis, starting with mining activities. So as to recall, validating mechanism by supply of computing power. Here, the income at stake is the reward of new tokens, new coins, and the transaction fees on the transaction validated. In this case, if we consider that income as a result of the validation work itself of the miner and the supply of computing power, but especially the validation work, we could see it as business profit according to Article 7. Otherwise, it's a bit stretched, I know, but if we look like, first of all, at mining farms, we could see that income as the product of that huge premises, huge mining farms. So maybe why not income from immovable property? A bit stretched, I know, but just in this situation, we could foresee it. If none of the above applies, we can always tax with Article 21, of course, and we'll see here the source of income and attribution of taxi rights, quite problematic. Why? Because if we apply Article 7, it means we need, in order to, having taxing rights in the source state, find a PE there. So a PE means a fixed place of business, maybe premises, personnel, or servers, or an agent PE. In particular, concerning server, we may have a server PE that is existent in the source state, even though maybe if we manage to actually say there is a server PE in the source state, an allocation key is not straightforward, right? So we don't know which server is currently operating on that specific transaction. It's very complicated. Anyway, at the end of the day, applying Article 7, taxation was going to be probably in the resident state of the miner, and maybe if we can manage to find a PE in the source state, it's going to be located there. I also put no agent PE because solo miners, meaning people, individuals, validated transactions are generally working on their own, so with no company backing them. And finally, Article 6, well, of course, taxation in that case would occur where the computers are installed. For liquidity mining, meaning the supply of tokens for investment purposes, meaning a loan, some kind of DeFi participatory loan, in that case, the income at stake is a fraction of the income realized by the borrower. Here, of course, according to us, depending on the lender's participation in the risk, so the liquidity provider, it could be dividends according to Article 10 or interest according to Article 11. In this case, taxation would occur in the recipient's resident state, of course, unless there is a permanent establishment in the source state, but quite difficult to establish. Here I put a small diagram I made just to show you the interaction between liquidity mining and staking that we're going to see in the next slide. You have the liquidity provider on the left side making a contribution to a liquidity pool, and then you have crypto traders that borrow those tokens in order to do some investments. And then the fraction of their income goes back to the liquidity pool and goes back to the first liquidity provider in the form of a token. With that specific token, we could foresee, for example, a staking mechanism on another crypto exchange, or maybe on the wallet itself if it allows that, and then staking rewards going back to the liquidity provider. So we can see, the interaction between those two different mechanisms and how it can be very interesting for the liquidity provider at the end. Moving on to staking activities. As I said, validating mechanisms via pledging of tokens. Here, the reward is the same we're having with mining activities. However, I only see that there is a small difference compared to mining. In mining, you have the role of servers, the role of computers, which is huge. Here, with staking activities, I don't see that. I just see that we're pledging tokens, and because of those tokens we pledged, we can validate transactions, and there is our work there that is deployed. In that case, I would apply business profits, Article 7. In any way, I wouldn't apply passive income provisions. So according to me and my professor, it shouldn't be passive income coming from staking activities. But of course, we can debate on that. Also, one more point about that. Yeah, it is a proper activity. Why? Because we can even delegate it. So staking activities, at least staking power can be delegated to other people. So we're still owners of our tokens, but we can delegate the power of validating mechanisms to other people. So source of income and attribution of taxing rights. If we apply Article 7, of course, we should ask ourselves, is there a permanent establishment in the form of servers PE? Yes, why not? But I think there is not a sufficient link in order to establish that, much weaker than compared to mining activities. So at the end of the day, taxation should occur where the recipient is located. Ownership of tokens, here it's very wide, meaning any persons that hold tokens for investment purposes, no matter the nature of the token. So here is any income deriving from that ownership, and it could take any form. It's very complicated, to establish a rule of thumb. So generally it could be business activity, of course, Article 7, but it could also be Article 10 or 11 if we're having some income streams that are similar to dividend or interest, meaning ownership rights or other kind of entitlements that go in that way. Or maybe you may have payments that recall royalties because there is a conferral of IP rights. Okay, especially in the case of NFTs, this is absolutely that's the case quite often. So application of Article 12. In case of application of Article 7, again, possible server PE, but we're not very satisfied with this solution. It's not enough. The localization of stakeholders is complicated. Allocating taxing rights is complicated, even if we find that there is a server PE. So at the end of the day, yes, it's always the resident state of the recipient of the income. But we'll see here, I put where the blockchain operates. It's actually the solution. I'm going to discuss it later. But yeah, if we apply this provision, it's going to be in the resident state. Idem for Article 12, 10, and 11, it's going to be taxed in the recipient's resident state, unless, of course, there is a permanent establishment. Last transaction, sale and trading activities of tokens. So it could be sale on the primary market, for example, an artist tokenizing his own digital or work of art or physical work of arts and selling them on a digital platform, or could be trade for more financial instruments on the secondary market crypto exchanges. In that case, we're discussing about any kind of capital gain or income that derives from this sale or trade, but also conferral of IP rights. So in this case, of course, a huge distinction should be made according to whether it's a transfer of digital products for personal use and enjoyment. In that case, of course, we're witnessing an acquisition of data, and we should apply Article 7, so business profits, or capital gain, Article 13, while if it's a mere download of digital products, same nature, for the use of IP rights, then of course it would be royalties, so Article 12. So in this case, same mechanism with Article 7. allocating taxing rights is impossible. I mean, not straightforward at all and not satisfying as a solution. So we end up always with the recipient's resident state. And for Article 12 or 13, recipient of the royalties in case we having royalties, or just the seller resident state if we having capital gain. So in conclusion, we can understand that the current OECD rules don't cover all these decentralized and digitalized activities. So these businesses, these individuals working on this kind of infrastructures, and we're having huge problems with qualification of the income and also the source of this income related to all kind of crypto assets. So yeah, of course, there is a need for a revision of, PE's concept first, absolutely, in order to encompass more those kind of decentralized businesses. We want to reach a more efficient taxing, rights distribution, and according to us, a solution would be to focus on all those market jurisdiction, meaning where the protocol or the digital platform or the crypto exchanges operate in order to be able to allocate better, taxing rights. So amendments are needed in this sense. Thank you for your attention.
Thank you, Martina. Let us connect with Professor English.
I solved the issue. Here's the law.
We can hear you. Yes, we can hear you.
That's good because I can hardly hear you now. But okay. Thank you very much for this presentation. I'm sorry I couldn't introduce it. I had some technical issues apparently. Welcome everybody. My name is Joachim, English, University of Münster, Germany. I'm very happy to chair this panel together with my colleague Professor Popov, of course, obviously sharing it online is a challenge, as we could see. But anyways, that was really an interesting presentation that raised a lot of intriguing issues. Personally, I say Article 6, movable property seems very far-fetched to me, even when it comes to the traditional approval work approach. And I also wonder whether we really need to discuss much the situations where tokens basically just replicate instruments that exist already in the classical world. So security tokens in particular would just replicate traditional token equity instruments. So it's obvious to me that then Article 10 or 11 would apply. But I guess I really feel that the new proof of stake concept, as well as NFTs, raise important issues that are less clear. And I think we probably should focus our debate on this. I'd like to invite the panelists to give their comments, and being aware of time, I think we might have time for one or two questions from the audience, which I would like to ask my co-chair, Professor Popov, then to handle, because it's a bit difficult from here to see who's showing up. So if I could ask the panelists to speak first, please.
Well, small intervention. My name is Popović rather than Popov. Okay. Not at all. That's fine.
So may I? Okay, so thank you very much, Martina, for this wonderful presentation. I really enjoyed reading your paper. I have one comment and one question for you. So the comment is just sharing with you and the audience that very recently in Spain we have seen published a tax ruling by the tax authorities regarding income from staking activities, in which they take exactly the opposite way that you lay down in your paper, which, don't take me wrong, doesn't mean that you're wrong. On the other hand, what I think is that you are totally right, because your paper raises the issue that the income characterization of these activities will trigger real problems. And I think this is a first example, at least I have to give it to you. So if you want, I can share with you that tax ruling. Basically, what the Spanish tax authorities say is that the income from staking activities should be characterized as interest income.
Interest income.
Yeah, income as a consideration for lending capital.
Yeah.
Whether they are right or not, I leave it for you that you have studied a lot about this. My question is regarding income from mining activities. So in your paper, you define mining activities, if I understood well, as a mix of providing computer power plus validation activity.
Yes.
And let's leave aside for one moment, because I don't feel very comfortable with Article 6 in this, but then what you say is, okay, let's see if it's Article 7 or Article 21 that should apply to this type of income. And then you say, if I understood correctly, please correct me if I'm wrong, well, if the focus is on the provision of computer power, it would be more of a passive nature of the income. So probably it would be Article 21. Whereas if the focus is on the validation activity, probably we should regard it as active income and we should go to Article 7. But I didn't see, let's say, a final opinion on it. So, and please, I have no knowledge at all apart from what I read from your paper. But is this validation activity an activity that really needs special knowledge by the miner? I'm not a miner myself. I haven't seen these miners acting. Does it require, let's say, a true involvement on it? Do you really need to devote time to this validation activity? Perhaps that would be some clues to address the question. And the question is, do you feel more comfortable with active income, so Article 7, or passive income, Article 21?
Absolutely.
Thank you.
So going back to your first remark on the Spanish ruling, I really don't see how it could be passive income from staking activities, because there is a real activity that is deployed so much that it can actually be delegated, as I said. So I really don't see why you should consider them as interest payments, especially because you have liquidity mining that fills out that definition. Like there you have tokens that are borrowed by investors, and then you have incomes that goes back to the liquidity provider. So there I would understand passive income streams, but not in the case of staking. But I would be interested in reading the ruling. And for your second question, I know, well, it's leaving aside Article 6, which is I know quite stretched, but going back to Article 7 or 21, it's difficult to take a position. I understand that active involvement of the miner is not properly there. We could discuss, like, yes, there is a setup to put in place, like downloading some software, maybe having a little bit of knowledge of what we're doing. So we had to do some studies, before becoming a miner. So we could discuss in that way. But yes, at the end of the day, there could be a debate on that point, of course, and we may end up on Article 21. I couldn't take a strong position on that. I'd say, we try with Article 7, and if really cannot prove that there is an involvement, there is a real activity that is deployed, then we fall into Article 21. There's Vikram with my question.
There is an idea that since we have Dr. Turina's paper, which is closely connected with this one, to proceed with the presentation by Alessandro Turina, and then we will have the joint comments by the panelists and you in the audience. In that way, we will somehow manage these delays we are already enjoying. So if Dr. English agrees with me, I think that we could now give the floor to Dr. Alessandro Turina from IBFD, who prepared the paper on how have the exchange of information data protection standard evolve, especially in the cryptos domain. And then we will go further. Dr. Turina, please.
For the introduction, and well, I would like to thank it's not just a sort of complying with the usual courtesy, but I've been lucky enough to call all of the founders of this cutting edge group, which to me is like the biggest change. I mean, this is, I think, perhaps even the most interesting event really for this year, to call them colleagues. And in the past, because we people then move ahead, but and still call them friends. So it's a huge privilege, and a special word of thanks to our most gracious host, Professor Kostic, and for the wonderful hospitality, and in particular also, as usual, I would like to thank him for his introduction this morning, because he gave me something to think about the history. Very learned, as usual, on the history of his country and the city. And I think, of course, maybe it may seem like first we talked about mobility, now first influencers. So again, mobility, crypto assets, perhaps, how do they fit? I think there's a red thread. So if we are in Belgrade version 45, if I'm not mistaken, this, I think it's a telltale that as the, let's say, international relations adage goes, geography is destiny, no? And I think the red thread of this day is basically that we are trying to cope, if this is true still, we're trying to cope with a world that is trying to get rid of geography in a way. And so we will see it, I think, also with regard to this crypto assets. My perspective is complementary to the one by Mrs. Danz, whose paper I found truly enlightening, as I'm not, let's say, I'm a sort of layman when it comes to cryptocurrencies. It's my first venture into this field. I've worked a bit in general in exchange of information, and what we may refer to as enforcement jurisdiction. So the perspective of this paper will be primarily enforcement jurisdiction with regard to crypto assets. What do we mean by enforcement jurisdiction? Just to make sure we're all on the same page, it needs to be juxtaposed to substantive jurisdiction, in the sense that substantive jurisdiction has to do with the question of the power of a country to impose tax on a subject matter of exaction. So essentially the question, who gets to tax what, who has the right to tax, let's say, something. And of course, it presupposes what I think Martina did in a very innovative and thoughtful way. It presupposes some sort of categorization, since we have a sort of let's say schedular system of sort. I mean, this type of logic is governed by still a sort of schedular approach. My concern, my angle is a different one, and it should really come second logically in the various, let's say, if you think about the process, the pipeline of taxation, and it has to do with essentially the power of the country to actually compel collection of tax over which it has jurisdiction. And of course, in order to collect, you also need to know. No, you cannot collect what you don't know it exists. So typically, first you would have to fix your claims when it comes to substantive jurisdiction, and after this, get engaged with enforcement jurisdiction. In the area of crypto assets, if I'm not mistaken, it seems that the reversed approach has been undertaken. So there's a relatively developed framework, although not final with regard to enforcement, but very little when it comes to substantive matters. So what I would like to do, I mean, after having defined a little bit the scope of analysis, is to adopt somehow of a UFO approach. So update, focus, and outlook may be familiar to you if you attend IFA events in particular. I think it's a common template. And so what is perhaps the two items that are of the greatest topical relevance are the sort of tale of two cities. So Paris, understood as the site of the OECD, and Brussels as the site of European institutions, because they've been invested with a lot of work in the specific area of enforcement jurisdiction on crypto assets. So let's start with essentially the OECD perspective. But first, I think it's appropriate to, and once again we go to this red thread of let's say a post-geographic world with the inherent challenges which I think make dealing with enforcement tax jurisdiction particularly arduous with regard to crypto assets. I would say there are challenges on almost all levels, subjective. So essentially, you have to deal with pseudo-anonymity, which is not anonymity, and so it raises, let's say, questions from both sides, so to say. And linked to the subjective dimension, I would say also the instrumental one, because when it comes to other categories of assets, at the end of the day, I think also relying on what Martina introduced, I think the main question would really revolve around the ownership of these assets. So typically, with regard to other financial assets, you can rely on intermediaries. It's something quite established. Here you have a complete disintermediation. We talk about decentralized finance, not by chance. And then you have the objective perspective, so dematerialization. I mean, what are these tokens? At the end of the day, they're lines of code and something to which you access through a public code and a private code. And then, of course, locational, because we are dealing with deterritorialization. Of course, it's somehow of a charged term. Maybe I'm using it a bit, let's say, improperly here, but I think it's clear that if in general income lacks geographical properties, in particular this type of income, however you may define it, you may categorize it, really exacerbates with this deterritorialization trend. But this being said, in terms of very big picture, this is essentially what, just to give you a little bit of a glimpse of what has been moving around. So the OECD has been quite an early mover already. Last spring, it came out with essentially a sort of modular complement to the existing common reporting standard called the Crypto Asset Reforming Framework. This is just the first block in the sense that essentially it's a set of model rules with a commentary. There has been a public consultation which received a lot of inputs from the industry primarily. What is basically also in the pipeline will be, once the CARF rules are defined, a sort of a competent authority agreement model, so the one that will essentially enable exchange of information. And then also very important, of course, in this case, the whole issue of IT platform, so how to make this thing actually work. And I don't think I have the time to really delve, let's say, too much into the specifics of this proposal, but I would say it boils down essentially to trying to understand what does ownership of these assets entails. That's, I think, the question that is not really formulated, but that is sort of inherent to the whole effort. When it comes to the material scope, it's quite easy because they have a sort of catch-all approach. So anything that is not a closed-loop crypto asset, so something you can use maybe just within a very specific segment, or which is not a central bank digital currency, which is also a very interesting development I will not be able to address, unfortunately, is essentially included in the scope of this reporting. And also very broad is the definition of what is reporting crypto asset service providers. This would equate essentially what in the CRS jargon are essentially these reporting intermediaries. So an individual or entity does as a business, so they have to do it, let's say, provides a service between exchange transaction with the counterparty, or as an intermediary to such an exchange transaction, or by making available a trading platform. So essentially all the possible ways in which you can be involved in this type of ownership transfer are covered. The type of transactions that are covered are also, I would say, sort of exhaust, let's say, the possible, when it comes at least to the transfer of ownership, which once again is the underlying main rationale of the proposal. So exchanges between crypto assets and fiat currencies, so sort of these Chinese walls between two types of, let's say, currencies, exchange between one or more form of crypto assets, so from NFT to, let's say, e-monies, or reportable retail payment transactions, so when you use it essentially to purchase something, and transfer of crypto assets, which is perhaps the most obvious situation, where you transfer to another owner, or maybe if you have more than one wallet, so to say, which is a sort of digital place where you store, not really, if I understand correctly, not really the actual currencies, but rather the codes to these currencies, because the currencies themselves, well, actually entail, well, it's very hard to separate the code from the currencies, essentially. And this will be made available through digital due diligence requirements that sort of mimic what you already see with regard to CRS. So self-certification, which is what you have right now with CRS, plus a sort of reasonable test based primarily on anti-money laundering, know your customer rules. I think while the first leg makes sense because it sort of equalizes the two realms, this latter sort of double check is where I think the devil is in the details. And here, unfortunately, the details are not clear at all. Not only because, of course, these FATF recommendations are not with regard at least to crypto, if I understand correctly, well, in general, their legal status is disputable, but they're not binding, but also because we will see that, for instance, with regard to the EU perspective, I mean, the EU being a very large market, something happened very recently that may sort of revolutionize the landscape. Then there are other side issues that are also quite important. For instance, can we rely on information that has been achieved through and collected by other persons who are not intermediaries? Or what are the implications in case of I think in the FATCA jargon there was this recalcitrant account owners. So what do you do with recalcitrant e-money owners? Essentially, do you stop executing their orders? That's also not very clear. And then, as I said, it's a tale of two cities. So the view from Brussels is that exactly yesterday, I think that shows the soft power of this research network, because they had it, they sort of encourage the reaching of an agreement at the council level on this markets in crypto assets proposal, which essentially will entail a regulation, so something that will be directly applicable across the EU, and also an amendment of an existing directive of breaches of EU law, so a little bit broad, but essentially this will be, if you're familiar with the EU financial regulation framework, the equivalent of the MiFID, but applied also to crypto assets, essentially. And you can see, I think the slides will be shared. So the proposal with all the various of essentially reports and impact assessment studies is available at this link. Really, I mean, some sort of breaking news. And the issue that even though, of course, this is not primarily a tax-related measure, it creates categories, it creates definitions that I guess would be hard to do without, or would have to be reconciled with the reporting framework. And perhaps it's not a coincidence that the equivalent of the CARF from an EU perspective, which most likely in the long term may simply translate into a transposition of the CARF into the EU framework, exactly what happened with TRS, and I think it was DAC 3, if I'm not mistaken, or DAC 2 maybe. So essentially, you transpose a global standard into the EU order. I think that was the original idea, but I think this will be something more difficult to achieve because essentially can you hear me? Yes. The OECD CARF essentially does without this common regulatory framework. Is a little bit up in, it starts from the roof, so to say. The EU has been as not being a first mover in this regard, so perhaps they also wanted to wait for the outcome of this MiCA work. But now the EU will be a little bit behind with regard to reporting, but more advanced with regard to regulation. And the question is, would this new regulatory framework, which concretized and whose outcome was not so obvious, because it's true that was adopted on a different legal basis from the one with which we are familiar for taxes, so it didn't require really unanimity, but still there were a lot of diverging views, let's say, in this matter, and eventually it came across. It needs to go through the parliament, but that should be quite, I mean, not really a rocky journey. So exciting times. A few selected issues. What does this entail for certain fundamental rights, primarily of taxpayers, but to some extent also intermediaries? And I would argue that data protection is the most obvious one, because as I said, this let's say crypto assets rely not really on full-fledged anonymity, but rather on pseudo-anonymity. So you're entitled to keep your pseudonym. It's like a little bit your nom de plume, but at the end of the day, they will find out who you are. So it's at the same time, we will see there are certain peculiarities associated with the coding aspect of it that may make this let's say this veil difficult to penetrate, to unveil. And it's interesting because actually this very proposal of the MiCA regulation, which was approved yesterday, attracted the attention of the European Supervision on Data Protection. So basically they found that it contained quite a few issues. And one of the, let's say, main points was that it was not clear who would be responsible for managing, let's say, this data, personal data protection. In this regard, I think it's very interesting also the development we have observed at the EU Court of Justice level with regard to GDPR and taxes. At the end of the day, it seems that the GDPR is not really bulletproof when it comes to, let's say, requests by tax authorities. In principle, yes. I mean, in principle, tax administrations can ask the information. There are, however, two, let's say, red lines not to cross, which in my mind, if my understanding is correct, appear very problematic when referred to crypto assets. First one is that it needs to be clear what is the specific purpose of the collection of the information. And now here we don't have a clear idea of the categories. So we know what we're going to ask, but we don't really know whether it's going to be useful because we don't know which kind of tax scriptum we should, let's say, we should apply to the various let's say, constellations of possible transactions. The second item that I think is quite problematic is that one of the recommendations that can be derived from this case is that the holding of the data should not exceed the duration strictly necessary to achieve the objective. Now, if my understanding is correct, I mean, the whole cryptocurrency relies on blockchain, and blockchain is something where you cannot really delete what is, I mean, it goes line by line, it's not possible to go backwards. So blockchain, in other words, does not go hand in hand to the right to oblivion. So essentially, this I think is a very sensitive point that may come back in the future. And we said that the perspective is one that is concerned with enforcement. Actually, yes. Just a couple of minutes and I will conclude. I just the inherent hurdle with tax collection is that, of course, there are different tax qualifications. We mentioned the Spanish example. We mentioned, I think, creative input by Martina. We'll get in touch with international organizations also. And it's very easy to manipulate, and I think there are different ways in which you can hold the crypto assets. So you have exchanges, which is the blue one, so the safest ones. Essentially, it's not really a direct holding of the crypto assets. You simply have a sort of account with intermediary and sort of debit credit relationship. Then custodial wallets, where essentially the intermediary has access also to the private key, in fact, so something can be done. But then you have cold wallets and non-custodial wallets that in different forms basically entail that even though the owner may be only pseudo-anonymous, so not completely anonymous, but still is in the sole, let's say the material possession is in her sole prerogatives. Cold wallets, that should give you an idea, actually work as a sort of USB sticks where you carry the codes. So how can you collect this? Either by decrypting the information, so using sort of the new Turings, or the new Nashes getting hired by tax authorities to decode this, or otherwise by relying on the use of force. So my impression is that essentially the whole crypto asset subject matter is problematic from the point of view of balancing the prerogatives of the state, the fiscal interest, we may say, and the safeguard of fundamental rights, essentially because the exercise of enforcement jurisdiction is simply much more complex, incomparably much more complex compared to other situations. And so we need to think about new categories and perhaps well, I leave some open questions here just to conclude and quote again, I think our colleague, Professor Kostic, he mentioned about interrogators meeting farmers here. Yesterday I was at a conference on the digitalization of public administrations in Naples, and one of the speakers from the public administration said that, yes, we are a bit the Neanderthals of the public administration. And one of the peculiarity of the Neanderthals, well, first, they came a bit earlier than Homo sapiens, but also they had a little bit of a more aggressive streak. And so my concern is that hopefully tax administration will not behave as Neanderthals vis-a-vis, so let's say with very little knowledge and let's say high levels of aggression. Thank you, and sorry for taking more time.
Thank you, Alessandro. Now, let us first hear from our panelists.
Thank you very much, Alessandro, for your presentation again. So I have a piece of info to share again with the audience. Again, I have to refer to my country, but I think this is also about sharing new developments. And then from that, I will raise some questions for you, Alessandro. So in Spain, basically, we are expecting as soon as for next year, three new reporting obligations regarding cryptocurrencies. First one would be by the wallet service providers. They will have to report the cryptocurrencies they have under custody, and they will have to identify the owners or the UBOs, so to speak. Then the second annual reporting obligation will be for I will say it, for cryptocurrency service exchange providers. And then there's another one, which will be for the taxpayers, who will have to report all cryptocurrencies they hold in wallets outside Spain. Understanding by wallets outside Spain, those who are not reported by the Spanish wallet service providers. And then my question is, after your research and study of this, are these aligned with the preparatory works of the OECD and the EU on the matter? Your gut feeling, I don't expect, of course, a very developed answer, but your gut feeling is that this is in the good direction? You think it will be easy to enforce?
Thank you very much for the question. And I noticed that Spain is a sort of laboratory for a lot of innovations in this area. But the point, I guess, so just two comments, one on the method and one on the merit, let's say, of the matter. On the method, what I think it's good to start getting things on the move, but there are some extra costs associated with being early movers here, especially because this sort of broader regulatory framework, not only on tax but in general on what are the rules of the games of this from a financial regulation perspective, and we're not really clear. I would say they're still not really clear because we don't have the regulation out yet. But until yesterday, it was a big question mark. So perhaps starting to go in a certain direction when things may take a different evolution may exacerbate the problem, because especially in the perspective of let's say intermediaries, they have to maybe set up a system of reporting and then maybe the rules of the game change. That's something that we saw, I think, with CRS. Of course, there was reporting before CRS, but then each intermediary had to adapt their systems to the new standard. So that would be, let's say, my question. With regard to the method, with regard to the merit, the issue that I see is like a two-pronged approach. So you rely primarily on intermediaries, and then you ask for a sort of self-reporting by resident. And of course, this is very problematic from a, let's say, compliance viewpoint. I think there are studies that demonstrate if there is no sort of fact-checking from the other side, I think compliance goes down by like 50% or so, which seems to me quite optimistic, but maybe because of my original, let's say, affiliation. But still, so unless you have a robust mechanism for verifying what, let's say, taxpayers self-report, it seems to me more like a sort of signaling type of thing rather than something that will really have a bite. But it's very interesting. I was not aware of these developments, let's say, specifically, that they were so concrete, and so it's thank you for this contribution.
Thank you very much. They are draft regulations anyway, but I think I agree with your viewpoint.
After having heard Dr. Turina's presentation, I must admit that I remain impressed by the enormity of the task tax administrations will have to face with. There are around 200 states and jurisdictions in the world, and I guess that one may find quite a number of them that are not ready to comply with the proposed OECD crypto asset reporting framework. You may tell me that BEPS was quite a success, but I bear in mind that Russian aggression on Ukraine has pushed the world into a phase which is very different from the 2013 cooperative BEPS mood. Subversion rather than cooperation, denial rather than exchange of tax information could become new features of the international landscape in the years to come. This may not have a direct impact on OECD and EU member states, because they will continue to behave in good faith, at least as a rule. But the existence of safe havens for tax evaders in the states that are otherwise exposed to sanctions like Russia or Belarus, and perhaps in some others, could undermine certain cooperation principles advocated by OECD. I would appreciate if Alessandro and other participants could comment on these, to an extent, my pessimistic predictions.
So, thank you very much, Professor Popović. I don't have much to say because I simply wholeheartedly and definitely agree with what you just said. Perhaps just bring a little bit of a concrete example of, let's say, new rogue countries when it comes to financial regulation, particularly with the area of crypto. I can bring the example of Iran. Iran is, of course, being on sanctions for several decades. It's also very troubled economically, and so at the same time, it's a population. I think it's perhaps Professor Browner may confirm, but I think it's one of, if not the leading, among the leading population when it comes to brain drain. So very good, let's say, educated base, very young population. So cryptocurrencies were like welcomed as perhaps the only way where you could put your savings, or at least and the regulations are basically kept at a very minimalistic level. So I understand that there is indeed someone using already Iran, just to make an example I'm familiar with, as a sort of stepping stone for also with regard to, but now it's already quite it's still quite unclear the regulatory framework. But in the future, if we were to converge maybe part of the world, towards a sort of common framework, still there will be patches, and it will be much more difficult to address them, I think, because of the very nature of the instrument, in this case of crypto assets, which are simply lines of codes once again. So something very difficult to monitor and control.
Thank you. Let us give the floor to Professor Englisch.
Much. So now we will have the last paper of this session. Thank you very much. So now we will have the last paper of this session, which is related to the use of artificial intelligence in the tax administration. More concretely, the paper that will be presented by colleagues Joshua Blank from University of California and Leigh Osofsky from the University of North Carolina is about the automation of tax guidance in the United States. So if I understood the paper correctly, about a sort of a chatbot used by the IRS in the United States to satisfy taxpayer information needs. And in their paper, Joshua and Leigh discussed the pitfalls of what they dub the simplicity phenomenon that comes along with the automated guidance, how it differs from the traditional written guidance, and what could be done about this in terms of solutions. So without further ado, the floor is yours.
Thank you so much to everyone for having us here and for organizing this incredible conference. The chapter that we submitted as part of this symposium examines how the rise of artificial intelligence in administrative guidance is producing a new phenomenon that we identify: automated legal guidance. Through online tools, virtual assistants, and other technologies, governments are increasingly relying on artificial intelligence to help the public understand and apply the law. We show that automated legal guidance often relies on what we have described in prior work as simplexity, where the government presents complex law as though it's simple without actually engaging in simplification of the underlying law. This approach offers potential gains in terms of efficiency and ease of use, but it also causes the government to present the law as simpler than it is, leading to less precise advice and potentially inaccurate legal positions. We argue that the use of simplexity in automated legal guidance is more powerful and pervasive than in static publication because it's personalized, non-qualified, and instantaneous. So first, what is automated legal guidance? Automated legal guidance has emerged from the rise of artificial intelligence. Now, defining artificial intelligence is difficult. It's an amorphous concept with no universally accepted definition. But it includes the use of machines in a way that approximates or augments human intelligence. Machine learning is one such type of intelligence, and it doesn't rely on formal logic. Machines can be trained to make highly intelligent predictions based on historical patterns and data. Machines may actually begin to teach themselves, developing more and more accurate predictions as they obtain more and more data. In the US, this development has not gone unnoticed by federal government agencies. Government agencies use artificial intelligence and machine learning to surveil, punish, and police. For example, the government has used machine learning to identify likely crime hotspots and recommend sentencing periods based on the likelihood of recidivism. This information is being used to make policing and even sentencing decisions today. Outside the criminal context, the SEC has indicated that it uses machine learning to identify potential fraud as well as systemic market risks. But the government does a lot more than just enforce the law. The government also provides services to the public. Of course, the government provides services like roads, national defense, and a variety of other public goods such as Social Security, but it also provides the service of making the public aware of the law and assisting the public in its need to access and comply with it. And the IRS is a prime illustration of this. In 1998, Congress enacted the IRS Restructuring and Reform Act, which emphasized the IRS's obligation not just to enforce the law, but also to provide customer service to taxpayers. As part of this restructuring, the IRS adopted the Taxpayer Bill of Rights, which states that all taxpayers have the right to clear explanations of the laws and IRS procedures in all tax forms, instructions, publications, notices, and correspondence. The combination of the rise in artificial intelligence and the government's use of guidance has led to a little noticed phenomenon. The government is using artificial intelligence to automate its guidance giving to the public. In its drive to improve its service, governments at all levels have been mimicking private industry's automated customer service representatives. And they have all sorts of faces and personalities. So consider a few examples. At the state level, Mississippi is using Missy, the first artificial conversational chatbot, and it's here to help with questions 24/7. At the federal level in the US, the United States is using Emma, a computer-generated virtual assistant for the US Citizenship and Immigration Services that promises to answer immigration and citizenship questions. You can even enable sound to have Emma speak your answer to you in English or in Spanish. At an international level, other governments are also using artificial intelligence to make conversational leaps. For instance, the Australian Taxation Office created Alex, a virtual assistant, to help Australian taxpayers with their tax questions. I'll turn it over now to my colleague Josh, who will explain how iOS is publicizing more and more its use of these sorts of chatbots.
Thanks, Leigh. So I will just describe an example in the tax context, the Interactive Tax Assistant. This is an online tool that the IRS has created that answers tax law questions on a range of topics, including what's taxable, what tax credits are you entitled to, it can answer questions about your filing status and many others. And instead of an electronic copy of an IRS publication or a printed summary of the law, the Interactive Tax Assistant asks the user to select a category. Can I deduct my medical and dental expenses, for example? And then after selecting a category, the user answers a series of questions. For example, are you itemizing your deductions? And after the taxpayer inputs the information, the Interactive Tax Assistant delivers an answer to the public. And so just to give you a sense of how the IRS has been publicizing this tool, I have an advertisement from our tax authority on the screen. This is an example, as Leigh described earlier, of what we call simplexity. This occurs where the government presents complex law as though it's simple, but it doesn't actually engage in simplification of the underlying law. Automated legal guidance offers gains in terms of efficiency and ease of use, but it also causes the government to present the law as simpler than it actually is, leading to less precise advice and potentially inaccurate legal positions. In many cases, EDA guides taxpayers to the correct legal answer without requiring them to comprehend and apply complex law, but sometimes it delivers answers that fail to fully explain the law, including exceptions, or it adds additional gloss to the law. While IDA can provide answers that are consistent with the tax law, it can deliver answers that deviate from it as a result of the use of complexity. Sometimes these deviations are helpful to taxpayers, but other times they are adverse. I'll just give you a couple of quick examples. When taxpayers have questions about issues that are relatively straightforward to explain, IDA is able to deliver accurate responses quickly and efficiently. I have on the screen, for example, a question about when you're required to file your tax return. However, sometimes IDA will deliver advice that is taxpayer favorable and deviates from the law. It can answer questions about basic issues like the due date for filing a tax return. However, where the legal question is more ambiguous, it can deliver answers that deviate from the underlying tax law in ways that are seemingly helpful to taxpayers. So just for example, I have on the screen a picture of artificial teeth. Imagine there's an aspiring model living in Los Angeles, where I am right now at 6:24 in the morning, who wants to alter his physical appearance, specifically his teeth. And this will help get jobs in print and online advertisements. And after having no luck with braces and other procedures, he visits an oral surgeon who says, you can replace these front teeth of yours with artificial teeth that will cost about $10,000. Can the taxpayer deduct this expense? Well, the interactive tax assistant, when you go to the interactive tax assistant and ask questions about your medical and dental expenses, has a whole category for artificial teeth. And very quickly, the interactive tax assistant says, yes, these are deductible. If the IRS were to audit this expense and learned that the model had arranged for the teeth replacement in order to obtain new jobs or more advertising opportunities, the IRS could challenge this deduction under a rule that says you can't get a tax deduction for cosmetic surgery. I'll give you another example just to describe how sometimes the interactive tax assistant deviates from the law in ways that are in conflict with taxpayers' interests. Consider a taxpayer who's a cancer survivor and has experienced several side effects from chemotherapy, including discolored patches on her teeth, and the taxpayer spends $1,000 to whiten her teeth. Well, if she delivers the interactive tax assistant and asks questions about teeth whitening, the interactive tax assistant immediately says these are not deductible. Despite that response and how unambiguous it sounds, the IRS has commented and stated in some of its guidance that teeth whitening could be deductible in certain circumstances, especially where the whitening is to correct disfigurement from a disease like cancer. So the automated legal guidance that we see in the interactive tax assistant presents the potential for even more pervasive and powerful forms of simplicity than what we see in static publications. Why? First, personalization. The IRS is speaking directly to the taxpayer. It uses words like you and yours. Second, automated legal guidance offers non-qualified answers to inquiries. Again, it even says the word answer at the top of the screen. There's no discussion of exceptions or how this might not be the answer. And finally, the automated legal guidance that we're describing delivers information almost immediately, and certainly much more quickly than a static written publication. As a result, the taxpayer doesn't have an incentive to do much additional research or even seek help from an advisor. Again, the interactive tax assistant provides an answer almost immediately. Leigh?
Thanks. So one question then is, how should automated legal guidance evolve in the future? First of all, we believe that the government needs to think about how it's going to use automated legal guidance to reach different user populations. When automated legal guidance relies on complexity to make otherwise complex law easily understandable, it tends to do so by reducing both the uncertainty that's inherent in standards and the complexity that flows from many rules. Now, this makes sense, or could make sense, for certain populations of taxpayers. For individuals of low income, the cost of applying uncertain or complex tax rules may be too high. These taxpayers also don't tend to have access to sophisticated legal advice. However, when using automated guidance for low-income taxpayers, it's also important not to systematically increase their tax liability. So for this user population, we argue that the government should adopt a pro-taxpayer default in automated legal guidance. Second, the government should think through administrative process. How should the government ensure adequate administrative process for automated legal guidance? As agencies turn to automated legal guidance to efficiently advise the public, we argue that the government should use automation as an additional trigger for oversight, review, and public comment in order to ensure that the agency guidance is considered to be legitimate. Josh.
And I'll just talk for just a few minutes, just to conclude. First, on penalties. Should the penalties for legal noncompliance apply even where individuals have followed the advice provided by automated legal guidance? We argue that the available defenses against penalties in the US can be reformed by adjusting the penalty defense rules and also the way that automated legal guidance works. So in terms of reform of the law, in the tax context, the Treasury Department in the US could revise the regulations that govern defenses against certain tax penalties, such as accuracy-related tax penalties, to allow taxpayers to assert a reasonable basis defense as a result of guidance they received from the interactive tax assistant, as long as they are acting, again, reasonably. In addition, we have a number of suggestions for how automated legal guidance itself could be reformed. One possibility could be to make it easy for taxpayers to reproduce a written record of every input into the interactive tax assistant and every answer, which they could use again to help establish a penalty defense. Just to conclude, how should automated legal guidance evolve? Should it rely on more or less complexity? In the future, it's possible that artificial intelligence could examine taxpayers' financial or other relevant transactions by monitoring email, bank records, physical locations, etc. Would this be desirable, this evolution in automated legal guidance? We believe our analysis in this article is essential to starting the process of thinking through these questions. One of the principal costs of future artificial intelligence would be the ability for people to understand what the law is. More sophisticated forms of AI may avoid some of the costs of complexity that we've examined, but some of the issues inherent in current forms of automated legal guidance will persist, and new dangers will be introduced. So in this chapter, we've offered a roadmap for how governments should evaluate these trade-offs and minimize costs as automated legal guidance evolves. Thank you very much. We look forward to the discussion.
Thank you very much for this great and interesting presentation. I think it was really highly illustrative also considering the examples that you gave. And I find three questions to be of particular interest. So how do we deal with this automated guidance based on what I would call weak AI? So basically decision tree AI, when it comes to protection of legitimate expectations or protection against the imposition of penalty. So how much should taxpayers be able to rely on this? That's a first important issue, I think. The second issue that you raised is what should this be used for? Where could be areas where this can really, where the benefits outweigh the downsides? And your suggestion as well, look at, say, low-income taxpayers and their needs. They will have less professional advice. I think that's probably something that's really worth discussing. And you could say, well, maybe we can transform that into certain areas of personal income taxation, such as personal deductions. So that might be an interesting aspect to discuss here. And finally, you mentioned the need for oversight. So I could imagine independent organizations like an ombudsman, or I think in the US, the Taxpayer Oversight Service, maybe getting involved in this. That is also something that we discuss here in Europe when it comes to the use of AI in the public administration in general. Do we need additional oversight outside or inside the administration? So with these ideas, I would like to now have our panelists have a say, and being conscious of time, I would ask them to have a say rather shortly and concise, and then maybe at the discretion of my co-chair, Professor Popović, we could have one or more questions from the audience. Thank you.
not only as a tax advisor, but also as a taxpayer, were basically two. First, whether this automated tax guidance by the tax authorities could be used in a biased pro-fiscal manner. And I saw that you gave examples, let's say, pro-taxpayer and pro-fiscal, but I'm not going through examples in Spain, but I can assure you that in some countries, as mine, and I think other people from the audience will sympathize if they come from other countries similar as mine, there are real examples of the use of technology by the Spanish tax authorities and of simplexity, as you call it, which have been very pro-fiscal, so to say. And this, for sure, shapes in some way the behavior of the taxpayers. And my second concern is about the, you also address it in your paper, the legitimacy of automated tax guidance. In other words, whether it could be used to some extent as a covert way of lawmaking. In other words, as well, is automated tax guidance the latest step on an ongoing process whereby the legislative power is being replaced by the executive power in the lawmaking process? And I'm really concerned about this, again, not only as a tax advisor, but also as a taxpayer. That's all. Thank you.
Thank you. We have time just for one question from the audience because we have already passed the deadline for the break. So if there is anyone of you who would like to raise the question, and it is you, please.
Yeah. Can you hear me? Oh. Well, there are two regarding the NFT that was issued before. No. Is that working? Okay. Regarding NFT that was working before, also referring to Professor Englisch's suggestion, do you think that actually the treatment of NFTs relate to the underlying asset? So would you treat the NFT according to the underlying asset? Because to me, the issue is whether there is a link between the two. Sorry, I was about to ask before, but I was not able to.
No problem. Thank you for your question. That's that's a very interesting issue indeed. But we're not sure about it. That's why we really have to distinguish digital assets that are tokenized and physical assets that are tokenized. Maybe one way to approach it would be to see if the tokenization of a physical asset, for example, a house, where it's possible, depending on the jurisdiction. In Switzerland, you can't do it yet, but maybe in other countries you can. You would have to look at the creation of any added value. Does the tokenization create added value, or is just a representation of the physical assets? In that case, maybe if there is more added value, because, for example, a tweet also, we can tokenize a tweet. Before tokenization, there wasn't any value of that tweet. Because we tokenized it, there is added value. So in that case, maybe we can look, at the NFT as the main object of taxation. While if there is no added value, like in the case of tokenization of a house, we just, apply the normal traditional rules we apply to taxation of immovable property. Maybe, why not? I don't know if it answered your question.
It is time for Professor Englisch's final remarks, if any.
Well, thank you very much, but I'm not sure, maybe the colleagues from the United States would like to very, very briefly comment on the questions, just very briefly.
Sure, thanks. I'll jump in. I have a few words, and I'm sure Josh does as well. So as far as the concern about the moving of lawmaking over from the legislative to the executive branch, that's certainly an issue, although a lot of it is already happening through the regulatory process. And so I think the concern is that it's happening in a much less supervised fashion here. And there's significant questions about who is supervising it. So we actually spoke to a lot of agencies about their process for developing automated guidance. And our findings were that the sorts of decisions made in this context tend to be made by low-level programmers rather than high-level agency officials. And so we certainly want to inculcate the process of the making and evaluation of these sort of tools with the same sort of internal procedures and protections that exist when more formal law that's available to more sophisticated parties is made. I'll just stop there and let Josh add any thoughts that he has.
Oh, well, I just wanted to thank everybody for the discussion and for the comments. Just a very quick response that I think applies to lots of questions we've received. In general, as you can tell, technology is making this form of guidance very attractive. In the U.S., this is, I think, even a more recent development than in some other countries. But the fact that now people can look on their phone and very quickly get an answer from the IRS is a new development. Yet our law has not caught up with this in terms of the administrative process that's used when the answers that something like the interactive tax assistant are designed, the transparency so we know who's making decisions and changes to what the website or the tool is saying. And finally, it's odd that people are suddenly being given this tool that they can use to get answers, but they can't rely on it to defend against tax penalties, and they can't bind the government to be forced to act in a way consistent with what one of these automated tools has said. These are all big questions that need to be considered. And again, I think this is just an example of how the technology is way ahead of what the law is responding to. We're used to the written publications, the Treasury regulations, and the other forms of traditional guidance, but not this new form of guidance. And so the law, we argue, needs to catch up.
Okay, thank you very much. I think that now really concludes our session. It was a privilege co-chairing it, and I really enjoyed it. I think we had 4 really thought-provoking papers, as we could see in the discussion. And I would like to once more thank all the rapporteurs, the panelists, and of course the audience. Thank you very much.